consensus. I don't think there's been any other that I'm aware of, agencies that have tried to do this yet.
Thank you. I think we are about the time, and this is the end of the session 3, and we'll have a break, about 15 minutes break. Well, 10 minutes break. We'll reconvene at 1:45 in session 4. Thank you all the speakers, and thank you all the attendees for participating. We'll see you later.
Great. Thank you.
Thank you.
Thank you.
Thanks.
Okay, my watch is showing that it's 1:45 Eastern time, so I think we'll go ahead and get started with the next session here. Welcome to session number 4. The title of this session is Regulation Surrounding CBD with a Focus on Consumer Products. For those of you who don't know me, my name is Leon Bruner, and I'll be chairing this last session. I'm currently adjunct professor at Michigan State University's Institute for Integrative Toxicology, and I'm helping Norb and the team in their work to advance CRIS. So I'll start off by thanking Norb and the team for putting together a great symposium. The topics that we've discussed so far have been very relevant and I think quite interesting for all of us. And so we appreciate the work that you did to put this symposium together, and also all the speakers who invested quite a lot of time in creating some really great presentations. A couple of housekeeping items for those of you who might just be joining us. If you have questions, it's easier for me to keep track of them as moderator. If you type them into the Q&A box, you can find that down at the bottom of your screen. And if you'd like to ask a question verbally, just raise your hand in the chat, and we'll call on you whenever we can. When there's time, we'll take questions at the end of each presentation, but otherwise we'll address your questions during the panel discussion that will take place at the last part of this session. So our first speaker this afternoon is Ricardo Carvajal. Ricardo is a director at Hyman, Phelps McNamara, a law firm that's based in Washington, D.C. that specializes in FDA and related regulatory matters. He served as an Associate Chief Counsel at the FDA in his early days, where he advised the agency on a variety of food-related enforcement and rulemaking activities. And today he helps clients manage inspections, warning letters, enforcement actions. He helps them resolve import detention, and he helps manage product recalls. He also advises on regulatory status of ingredients and finished products, provides guidance on compliance with labeling and advertising clients, and advertising requirements, and represents clients in advertising related dispute. And last but not least, he advises clients on interpreting and implementation of new regulations. So Ricardo is highly qualified and greatly experienced and knowledgeable on the topic that he's going to discuss today. Ricardo's presentation is titled Hemp-Derived CBD, a Primer on Key Regulatory Issues. So Ricardo, please go ahead.
Thank you very much for the introduction, Leon, and thanks also to Norb and his team for organizing a great symposium. So I was asked to give a brief high-level overview of key regulatory issues and regulation of CBD. And I think for our purposes, it's probably worth taking a very short trip down memory lane, looking back at the Farm Bill of 2018, which is where we got the current legal definition of hemp from. What that law did was authorize interstate commerce in hemp-derived products and establish a framework for regulation of hemp production to be overseen by USDA. But these last two bullets here are probably the most important for purposes of the next 20 minutes. That law left it up to states to decide whether to allow hemp production and marketing within their borders. And it also explicitly disclaimed any intent to affect or modify the Federal Food, Drug, and Cosmetic Act. I think, very important to start with a couple of basic things just to make sure we're all on the same page, because I know we have a mixed audience here, maybe some folks with a legal background, some folks probably primarily with a scientific background. But the Federal Food, Drug, Cosmetic Act is a strict liability statute. And what that means is that you are liable for violating it even when you didn't intend to violate it. And that law sets out a number of prohibited acts. Just to give you a couple of examples, the introduction into interstate commerce of an adulterated or misbranded food is a prohibited act. The introduction into interstate commerce of an unapproved new drug is a prohibited act. And these prohibited acts are potentially punishable by civil and criminal penalties. Potentially a misdemeanor if you didn't know you were breaking the law, and potentially a felony if your conduct was knowing and willful. A second key feature of the Federal Food, Drug, Cosmetic Act is that it's intended use that determines the regulatory status of an article. So is the article, and all these terms are defined by law, is it a food? Is it a drug? Is it a biologic? Is it a medical device? Is it a cosmetic or a tobacco product? Those are all terms defined in the Federal Food, Drug, Cosmetic Act. And you'll notice that the word tincture isn't in there. Salve, some of the other terms we hear tossed around in relation to CBD products. Ultimately, every CBD product is going to be evaluated according to the criteria in these definitions to try to figure out what box it belongs to for FDA regulatory purposes. So an article is food if it is used for food. That is literally what the law says. It's not a very helpful definition, but there it is. An article is a drug if it's intended to affect a structure or function of the body, unless of course it's food, or if it's intended to treat, cure, prevent, or mitigate a disease. Now, structure function claims are permitted for food, including dietary supplements, which under US law are a type of food, but disease claims are not. So rather than go through a whole laundry list of requirements, I thought we'd take this in the form of looking at different potential uses for CBD. So let's say use one is a use in dietary supplements. Well, because the Farm Bill didn't preclude application of the Federal Food, Drug, Cosmetic Act, any CBD product that is going to be marketed as a dietary supplement would have to meet all of the criteria that apply to dietary supplements. So the law defines the term dietary supplement and includes lists of a number of categories of what are referred to as dietary ingredients, which include an herb or other botanical or a concentrate of an herb or other botanical or extract. Further, if a dietary ingredient qualifies as new, meaning it wasn't marketed in the US before October 15th, 1994, then you might have to submit a pre-market notification to FDA unless the ingredient has been present in the food supply as an article used for food in a form in which the food has not been chemically altered. So there is a potential pre-market notification requirement that applies to new dietary ingredients. There have been few new dietary ingredient notifications that have been submitted for hemp-derived dietary ingredients. The last time I checked, it was only 2. And in both of those instances, FDA made a point of stating that its position on CBD was the same position you've already heard articulated earlier in some of the other presentations, namely that it can't be used as a dietary supplement. And I'll get into the explanation for that in a minute here. Additional fundamental requirements for a dietary supplement is that it has to be ingested. It can't be something that's inhaled or topically applied. It cannot be represented as a conventional food. And the safety standard is that it must not present a significant or unreasonable risk of illness or injury under the intended conditions of use or ordinary conditions of use. It also has to comply with the good manufacturing practice regulation applicable to dietary supplements and be labeled in accord with all requirements. And structure function claims are permissible, but must be adequately substantiated. Inadequate substantiation can give rise to liability under both federal and state laws. Now we come to where the rubber meets the road. The definition of dietary supplement excludes an article that is either approved as a drug or has been authorized for investigation as a new drug for which substantial clinical investigations have been and made public. And as you've already heard, FDA has approved a drug that contains CBD, and it's pursuant to that to that approval that FDA has raised an objection to the marketing of CBD products as dietary supplements. There is an exception if the article was previously marketed as a dietary supplement or food, referred to as the prior marketing exception, then the exclusion would not apply. Also, FDA can issue a regulation that would void the exclusion. So what is FDA's position? FDA's position is that, at least based on the evidence that has been made available to date, CBD products are excluded from this statutory definition of dietary supplement. So literally, under the law, they cannot be a dietary supplement. And FDA has pointed to the existence of the substantial clinical investigations regarding CBD that were made public in the context of Sativex and Epidiolex. The prior marketing exception, furthermore, does not apply, again, based on the evidence that FDA is aware of to date. So in other words, FDA has not seen evidence that CBD was marketed as a supplement or food before these substantial clinical investigations had begun. FDA has encouraged submission of relevant evidence and has indicated its willingness to consider rulemaking to void the exclusion, and I'll say a little bit more about that later. Let's consider a second use, food for humans. First off, the use of any substance in food potentially is subject to regulation as a food additive. And for a food additive to be lawfully used, it has to be the subject of a petition approved by FDA. Otherwise, the additive and any food containing the additive would be adulterated. There are some exceptions, most notably for the use in food of a substance that is generally recognized as safe by qualified experts, and a manufacturer can reach a GRAS conclusion without FDA's review and approval. And this you'll hear referred to by different terms. Sometimes it's referred to as GRAS self-determination or GRAS self-affirmation. FDA operates a voluntary GRAS notification program so that the company that makes a GRAS determination can choose to submit a notification to FDA of its GRAS determination. There have been several GRAS notices submitted for hemp-derived ingredients. 3 of those received a no questions letter, and that was accompanied by a little bit of fanfare by FDA, press release, and the works, just to show that that system does in fact work. Additional fundamental requirements for a food. The safety standard is very high, the highest really under the Federal Food, Drug, Cosmetic Act. There must be a reasonable certainty of no harm under the intended conditions of use. And just as with dietary supplements, there are extensive good manufacturing practice and preventive controls requirements that are intended to ensure the safety of food products. As with dietary supplements, claims of an effect on a structure or function of the body are permissible, but in the case of a conventional food, those claims have to derive from the ingredient's nutritive value. And here again, we run into the formidable obstacle of a statutory prohibition that says you can't add to food an approved drug or a drug for which substantial clinical investigations have been instituted and made public unless that article was previously marketed in food. So here again, we have a prior marketing exception in a provision that you can think of as the twin counterpart to the provision we just talked about for dietary supplements. And here again, FDA can issue a regulation that would void this prohibition. So FDA's position, absent prior marketing, and FDA is not aware of evidence of prior marketing of CBD in food. It's a prohibited act to distribute in interstate commerce any food to which has been added CBD. So based on the available evidence, FDA views essentially any food to which CBD has been added as a food to which a drug has been added, and has indicated a willingness to consider rulemaking to avoid the prohibition. Consider use 3. One of the hottest growing categories are food-like products marketed to animals, usually companion animals that contain CBD. Here again, we have the food additive GRAS framework, which applies. The option of GRAS self-determination is somewhat constrained by the fact that a number of states simply won't recognize a GRAS self-determination for a food ingredient used in animal food. Here again, FDA administers a voluntary GRAS notification process. You have the same very high safety standard, reasonable certainty of no harm. You have extensive GMPs. Structure function claims are permissible, but a little bit more constrained than is the case for human foods. And you have the same final obstacle, this application of section 301 LL, which FDA has indicated would apply in the case of CBD and the use of CBD in animal foods, even though the approval of CBD was obviously in a human drug. We also have an additional layer of complication in that pet foods are regulated and animal foods generally are regulated in part through the American Association of Feed Control Officials, which acts as another gatekeeper for the introduction of new ingredients into the animal food supply. So AAFCO administers establishment of new ingredient definitions, which effectively functions as an alternative to FDA's food additive approval and GRAS notification process. As yet, there hasn't been an ingredient definition that has moved forward for a hemp-derived ingredient. And because state systems of facility and product registration allow states to keep a very close eye on the animal food market, it can be a tough sector in which to enter and operate in a significant way. The final use I'll look at is cosmetics. With the exception of color additives, there's no pre-market review or approval of cosmetic ingredients. The drug exclusion provisions that we've been talking about do not apply. There's a fundamental safety requirement in that a cosmetic is adulterated if it bears or contains any poisonous or deleterious substance that might render it injurious to health. But short of that, the principal restriction to the marketing of a lot of products as cosmetics stems from the definition of cosmetic itself, because that means that a cosmetic can bear only claims that are consistent with the legal definition of that term. And that definition classifies cosmetic products as products that are used for cleansing, beautifying, promoting attractiveness, or altering appearance. So if a cosmetic bears a disease claim, that cosmetic is an unapproved new drug. Those claims simply are not permissible for cosmetics. And furthermore, any claim of an effect on a structure or function of the body would also not be permissible for a cosmetic product. So those are fairly significant restrictions that limit the types of claims that one could make for a cosmetic, particularly one that contains CBD. So what has been FDA's activity to date? Well, FDA has continued to give high priority to enforcement against CBD products marketed with disease claims. That is what FDA considers to be the low-hanging fruit. In some instances, FDA has been partnering with our Federal Trade Commission, or FTC, to target egregious violations with warning letters that have been issued jointly by both agencies. And I'll talk a little bit more about FTC's role in a minute. In the report on CBD that Congress submitted, that FDA submitted to Congress as directed to do by the Farm Bill, FDA reiterated that it continues to have questions about the safety of CBD, expressed serious concerns about risks posed by contaminants in CBD products, and expressed significant concerns about the use of false claims in the marketing of products to vulnerable populations, such as children. So I think we can all expect FDA to continue monitoring the marketplace, testing products for quality and for contamination, and issuing warning letters, again, most likely targeted to the egregious violators, the ones that are making disease prevention and treatment claims. So what is the Federal Trade Commission's view? Well, the Federal Trade Commission regulates advertising, and their principal focus is on whether advertising is truthful and not misleading, whether any claims of health benefits in advertising are adequately substantiated. So here, this is taken from FTC's website in response to comments and questions that have been submitted on one of the blog postings that FTC put up in the wake of one of these warning letters that it sent out. The FTC does not enforce the laws governing the permissibility of selling CBD products. We regulate advertising claims about CBD products already on the market. So claims about the health benefits of a CBD product must be supported by competent and reliable scientific evidence. The quantity and quality of that evidence varies by claim. In general, claims that a CBD product treats or prevents serious diseases or disorders or provides other drug-like health benefits require human clinical trials. If the advertiser is unable to amass such evidence due to regulatory or financial hurdles, then it should not make these types of claims. So that's FD&C putting down its marker, basically saying we're going to treat any health-related claims made for CBD products the same way we would treat health-related claims for any product, including foods, dietary supplements, whatever FTC crosses FTC's desk. FTC is going to hold that product to the same standard in terms of requiring a level of scientific support that experts in the field would regard as appropriate for the type of claim that's being made. So what about the states? We see a lot of these products out there, and a lot of them are out there because there are certain states that have gone forward with creating a market for these products. So here's a provision from Colorado law, which doesn't directly sanction the marketing of CBD products, but if you read what it says as Colorado has read it, or the Colorado regulators have read it, they're viewing it as essentially permitting the marketing of CBD products under state law. What the law actually says is, notwithstanding any other provision of law, a person engaged in processing, selling, transporting, possession, or otherwise distributing industrial hemp cultivated by a person registered under this article is not subject to any civil or criminal actions under Colorado law. So under Colorado law, you can move forward with the marketing of products derived from industrial hemp. And Colorado's principal regulator has looked at that language and is interpreting that language to allow the marketing of food products that contain CBD. Now, there are certain conditions that those products have to adhere to, and I've just laid out one of those conditions here, which is a set of labeling requirements. Any CBD product marketed as a food in Colorado has to clearly identify hemp as an ingredient, clearly identify CBD and the amount of CBD if added as an isolate, include the statement FDA has not evaluated this product for safety or efficacy, and not contain any health or benefit claims. So the latest in terms of developments that we've been monitoring, in July 2020, FDA submitted a draft guidance document titled Cannabidiol Enforcement Policy for review by the Office of Management and Budget at the White House. And that document remains under review. We don't know what the contents of that document are. FDA has been pretty tight-lipped about it, as they should, given that it's still in the review stage at the White House. No word on the timetable for completion of that review or when we can expect to see something come back out. In tandem with that, there has been federal legislation introduced that would override FDA's position regarding the exclusionary clause. I gave you here one reference to one law. There's at least a couple of laws or bills, I should say, that are pending. They take slightly different approaches to dealing with this problem of the exclusion from dietary supplement status or from addition to food. And they're fairly easy to find online if you just go to the repository of pending legislation and type in the term cannabidiol. There are additional states moving forward with legislation and regulations to permit the marketing of certain CBD products under state law. New York is one of them. They just in the past week announced their proposed regulation creating their framework for the marketing of hemp-derived products, including products that contain CBD. And then you know you've arrived when you start getting targeted by class action lawyers. And indeed, the class action lawyers have started targeting CBD products under a couple of different theories. One popular one is consumer fraud, essentially alleging that there's some kind of misrepresentation being made for the product regarding its content of CBD. And as we've seen through FDA's testing and other testing, there are indeed a good number of products out there that do not contain the amount of CBD that they claim to contain on the label. And then another possible approach is to sue under unfair competition or unlawful business practice laws. And here the argument is a little more legalistic. It's essentially taking the position that by marketing an allegedly unlawful product, and a dietary supplement that contains CBD would be an allegedly unlawful product, you're effectively gaining an unfair advantage and engaging in unlawful business practice. So key takeaways, the Farm Bill did not affect FDA's regulation of the use of CBD in food or any of the other product categories that we've just talked about. Manufacturers and distributors will assume liability for compliance with all applicable provisions of the Federal Food, Drug, Cosmetic Act and the Federal Trade Commission Act when it comes to claims used in advertising. The FDA regards ingestible CBD products as drugs, and it's pretty clear the agency is committed to preserving the integrity of the drug approval pathway, which is part of the objective behind that exclusionary clause. FDA's creation of a pathway for the lawful use of CBD in dietary supplements or conventional foods does not appear imminent. FDA has indicated an openness to having a dialogue and certainly wants to see as much information as folks can submit. But when you consider that the process that FDA would have to go through to avoid that exclusion is rulemaking, that is a long drawn out process. It would have to start with a notice of proposed rulemaking, if not an advanced notice of proposed rulemaking. And we have not seen an indication that something like that is in the works. In the interim, the food pathway clearly is open to hemp-derived ingredients that do not contain CBD. Finally, the manufacture and distribution of CBD products might or might not be prohibited or restricted under state law. And there's little choice but to just continue to monitor those state developments. And in the interim, it would seem that going forward with a product to market in all 50 states is a bit challenging, if for no other reason that you have different states adopting different requirements as to what needs to be on the label, among other things. So I'll stop there and happy to answer any questions.
Okay, great, Ricardo. That was a fabulous